criminals will always find guns.
Absolutely.
And it is the cities with the most restrictive gun policies in the country where...
If you were serious, you would acknowledge that 96% of mass public shootings happen in an area where guns are banned.
Banning a class of weapons that you don't like the look of, not because of functionality.
These pistol braces make a normal, law-abiding person suddenly a violent criminal is bizarre.
Certain bump stock devices, like the one used in Las Vegas, are illegal under current law.
ATF pistol brace. In a recent announcement, the ATF has unveiled an instant nationwide ban on certain pistols, intensifying an already heated debate surrounding Second Amendment rights. This move has stirred significant controversy, especially considering the ongoing legal battles over the ATF's pistol brace rule. Interestingly, despite the ATF's recent victory in a different federal court, the brace rule still faces a nationwide injunction. This development has left many grappling with the complex legal nuances surrounding the issue. A recent decision from a federal court in North Dakota has presented a conflicting perspective on the ATF's brace rule. This contrasts with a favorable ruling from the Fifth Circuit in the Mock v. Garland case, where the district court's initial denial of the plaintiff's request for a preliminary injunction was deemed incorrect. Consequently, the case was remanded to Judge Reed O'Connor for a fresh decision on the injunction. While this development in the Fifth Circuit offered a ray of hope for proponents of Second Amendment rights, the situation takes a turn due to a separate case in a different federal court in North Dakota.
Ban assault weapons, ban them again, do it now, enough, do something.
They were assaulted and shot by someone and couldn't defend themselves because their guns were taken from them.
The complexity of these legal battles highlights the multifaceted nature of the ATF's pistol brace rule, leaving observers on the edge regarding its potential implications for Second Amendment rights. As the legal landscape continues to evolve, it remains imperative for individuals invested in the Second Amendment debate to stay informed and engaged in the ongoing discourse. The intricacies of these cases have far-reaching implications, and understanding them is crucial for those passionate about preserving their constitutional rights. Legal battles unfold. In the recent legal proceedings, there has been a back and forth concerning said ATF's brace rule. One significant case took place in North Dakota, where the judge, unfortunately, denied the request for a preliminary injunction. This decision was influenced by the developments in the Fifth Circuit. The plaintiffs in the FRAC lawsuit argue that the rule constitutes a final agency action that surpasses the ATF's statutory authority. According to their perspective, the rule unnecessarily regulates pistols and other arms equipped with stabilizing braces, even though the statutes do not inherently address such weapons. The ATF contends that the new pistol brace rule is simply a clarification, aiming to close a perceived loophole in current law. They assert that individuals attempting to circumvent the law by using stabilizing braces should be subject to stricter regulations. The ATF also raised the issue of standing, arguing that the plaintiffs must provide evidence of specific arms with braces attached to challenge the rule effectively. They claim that only after undergoing the process under the new rule would the plaintiffs have standing to sue the ATF. In the parallel mock lawsuit in the Fifth Circuit, the court issued an administrative stay. District courts within the Fifth Circuit also granted temporary injunctions, safeguarding specific 2A organizations and their members.
The pistol brace also does not help the shooter load the pistol more quickly.
But, Madam Speaker, guns have been prevalent in the United States of America since before our founding.
After a hearing, the Fifth Circuit determined that the plaintiffs demonstrated a likelihood of success in challenging the rule, warranting the preliminary injunction. These legal battles underscore the complexity and contentiousness surrounding the ATF's brace rule. Fifth Circuit and FRAC case unraveled. In the recent legal skirmish over the ATF's brace rule, a pivotal turn of events occurred within the Fifth Circuit. After thorough deliberation, the Fifth Circuit Court came to a decisive conclusion. The plaintiffs had demonstrated a compelling likelihood of success on the merits. This finding held substantial weight in their pursuit of a preliminary injunction. As a result, the case was remanded to Judge Reed O'Connor for further examination. Judge O'Connor, known for his favorable stance towards Second Amendment rights, now holds the power to assess the remaining facets of the case. Given his pro 2A disposition, it's widely anticipated that he will indeed grant the injunction. This development, stemming from the Fifth Circuit, has set a precedent that carries significant influence over the ongoing frack case. Meanwhile, in North Dakota, the frack case met an unforeseen setback. Judge Daniel Holland, presiding over the case, delivered a ruling that denied the motion for a preliminary injunction. According to Judge Holland, the plaintiffs had fallen short in demonstrating a likelihood of success on the merits. This decision, in effect, put a halt to further review of the other elements that constituted the injunction, ultimately ruling in favor of the ATF. It's imperative to dissect the judge's commentary on the Second Amendment, which surfaced in the aftermath of the ruling. He made a categorical assertion. Certain types of arms, specifically short-barreled rifles, do not fall under the protection of the Second Amendment.
Turning law-abiding Americans into felons by banning pistol braces.
To propose regulations to ban all devices that turn legal weapons into machine guns.
Importantly, it should be noted that this particular lawsuit did not directly challenge the constitutionality of the final rule itself. Instead, it focused on its application and potential overreach. These recent legal developments shed light on the intricacies of the legal landscape surrounding the ATF's brace rule. They serve as a testament to the varying interpretations and applications of the law across different circuits and judges, ultimately impacting the outcome of these high-stakes cases. Second Amendment and regulations. In the recent ruling, the judge made several key legal observations that help frame the context of this case. Citing the landmark Supreme Court decision in District of Columbia v. Heller, the judge emphasized a crucial aspect of the Second Amendment. It does not confer protection to weapons that are not commonly owned by law-abiding citizens for lawful purposes. This principle has been extended by federal courts to include short-barreled rifles. The ATF's final rule, as outlined, establishes specific criteria for short-barreled rifles. Importantly, the judge underscored that this rule, in and of itself, does not implicate the Second Amendment any further. It is seen as a regulatory measure designed to define and govern the classification of arms, particularly short-barreled rifles. Furthermore, the judge delved into the broader legal framework governing firearm accessories or attachments. He drew a parallel to silencers, which have been legally established as accessories rather than standalone arms. This distinction, based on precedent, means that silencers do not fall under the protection of the Second Amendment as a bearable arm.
But at the crux of this is a bureaucrat making a unilateral decision to try to turn millions of Americans into felons.
It's mounted to the rear of the pistol. It's designed to anchor the pistol to the shooter's arm.
The judge then extends this analogy to stabilizing braces, positing that, like silencers, they lack the capability to cause harm independently. Thus, they too do not qualify as bearable arms, and by extension, are not covered by the Second Amendment's protections. In unambiguous terms, the judge asserted that the Second Amendment is not a central issue in this particular lawsuit. He emphasized that it does not grant an unqualified right to possess stabilizing braces or short-barreled rifles. Instead, he highlighted the constitutionality of reasonable licensing regulations associated with firearm ownership. This perspective underscores that the Second Amendment does not operate as an absolute barrier to regulations aimed at ensuring public safety and responsible arm ownership. Biden administration's new law. The Biden administration has recently introduced a new rule aimed at regulating the use of pistol braces, a move that could have significant implications for gun owners across the U.S. This rule, which was requested by President Joe Biden as part of his efforts to reform gun laws, effectively restricts the use of braces unless they are registered with the ATF. Failure to comply with this rule could result in federal charges carrying penalties of up to 10 years in prison, despite previous ATF rulings deeming the braces legal over the past decade. According to the ATF, firearms equipped with stabilizing braces or similar rearward attachments may undergo a new classification determination. However, a majority of the existing arms fitted with such braces are likely to be reclassified as rifles, primarily because they are configured for shoulder use. This reclassification means they would be subject to regulation and registration under both the National Firearms Act and the Gun Control Act. Many of these arms generally have barrels of less than 16 inches, further solidifying their status as short-barreled rifles.
It wasn't a fully automatic machine gun that was banned in 1986. It wasn't the bump stock.
Certain bump stock devices, like the one used in Las Vegas, are illegal under current law.
The ATF asserts that the majority of individuals in possession of a pistol brace-equipped arm are in violation of the NFA, as they possess an unregistered rifle with a barrel length of less than 16 inches. This new rule is poised to impact a substantial number of American arm owners, as the popularity of pistol braces has surged since the ATF's initial determination in 2012 that they did not convert pistols into a heavily regulated category of short-barrel rifles. Although the exact number of braces currently in circulation remains unclear, estimates suggest it ranges from 3 to 7 million devices. However, some sources, like the Congressional Research Service, put this figure much higher, between 10 and 40 million. The Biden administration's decision to proceed with this ban follows a substantial public outcry, with hundreds of thousands of comments opposing the regulation submitted during the public comment period. It also comes in the wake of the Fifth Circuit's ruling against the Trump-era bump stock ban, a policy implemented through a similar rulemaking process, and which faced legal challenges after the ATF had previously stated that bump stocks fell outside the purview of the NFA. This may indicate potential legal hurdles for the new pistol brace rule. Controversy surrounding ATF's rule change. The recent rule change implemented by ATF has ignited a heated debate surrounding gun regulations in the U.S. Attorney General Merrick Garland has defended this change, asserting that it is a crucial step in preventing crimes committed with firearms that he believes should be subject to the regulations set forth by the NFA. This development has drawn attention to the complex interplay between public safety and individual rights. In his statement, Attorney General Garland emphasized the department's unwavering commitment to prioritizing community safety. He pointed out that nearly a century ago, Congress took a definitive stance by subjecting short-barreled rifles to heightened requirements. The new rule seeks to make it unequivocally clear that firearm manufacturers, dealers, and individuals cannot sidestep these crucial public safety measures. This is achieved by preventing the addition of accessories to pistols that could effectively transform them into short-barreled rifles. The NFA, established in the 1930s, mandates that Americans register all rifles with barrels shorter than 16 inches and pay a $200 tax.
Why is the ATF trying to say a pistol's no longer a pistol? If you use a pistol brace, it's a short barrel rifle.
Partisans at the ATF have really run amok, infringing and trampling on the Second Amendment.
This inconsistency in the ATF's determinations has sparked growing complaints that the agency lacks a clear and objective measure for determining the legality of braces. Critics argue that this ambiguity leaves gun owners uncertain about whether they are in compliance with the law, leading to frustration and confusion within the arms community. The recent ATF rule change has reignited a contentious debate over gun regulations in the U.S. Attorney General Garland contends that this change is necessary to prevent crimes committed with arms that should be subject to NFA regulations. However, critics argue that the ATF's inconsistent determinations on pistol braces have created confusion and uncertainty within the firearms community. Striking a balance between upholding public safety and respecting individual rights remains a complex and contentious issue that will likely continue to shape the future of gun regulations in the U.S. Pistol brace rule faces strong opposition. The Biden administration's recent rule change regarding firearm accessories, specifically stabilizing braces, has sparked significant controversy and political debate. This rule, implemented by the ATF, aims to reclassify pistols equipped with stabilizing braces, potentially turning millions of law-abiding Americans into criminals overnight. The new regulation has been met with fierce opposition from various quarters, including lawmakers, gun rights advocates, and legal experts. The ATF's new rule seeks to provide clearer guidelines for the classification of arms with stabilizing braces. However, it still relies on subjective measures, such as assessing whether an accessory's marketing implies it is intended for shoulder use. This leaves room for interpretation and raises concerns about consistent application across different cases. Critics argue that this subjectivity undermines the clarity and fairness the rule purports to offer.
Could lose the ability to use these tools, and as a result, may not be able to operate their firearm.
These pistol braces make a normal, law-abiding person suddenly a violent criminal is bizarre.
The agency has outlined several options for individuals who own arms equipped with stabilizing braces to comply with the new rule. Owners must register such weapons under the National Firearms Act within 120 days of the rule's publication. Alternatively, they can opt to remove the short barrel and attach a 16-inch or longer rifle barrel, or permanently alter or dispose of the brace to prevent reattachment. Lastly, individuals may choose to surrender the arm to their local ATF office or have it destroyed. The ATF's rule change has faced widespread opposition on both political and public fronts. Hundreds of thousands of public comments were submitted during the rule's public comment period, expressing strong disapproval. In a letter addressed to Attorney General Merrick Garland, almost every member of the Senate Republican caucus demanded the withdrawal of the rule. They expressed concern that the rule could potentially criminalize millions of law-abiding citizens and create a historic gun registration and confiscation program. Advocacy groups have vowed to challenge the rule in court. Political and public opposition, as well as impending legal challenges, demonstrate the contentious nature of this regulatory change. As the debate continues, it remains to be seen how the rule will ultimately be implemented and enforced. Judge's distinct interpretation. The judge's decision in this case hinges on several key interpretations of the Second Amendment and the ATF's final rule regarding stabilizing braces for arms. His perspective is notably distinct from that of the Fifth Circuit Court in the Garland case. First and foremost, the judge contends that the Second Amendment is not a factor in this case. He asserts that the firearms in question, known as short-barreled rifles, are inherently dangerous and unusual. This classification, according to the judge, removes them from the scope of Second Amendment protections. Furthermore, the judge delves into the distinction between arms and accessories. He argues that accessories, such as stabilizing braces, do not qualify as arms and therefore do not fall under Second Amendment jurisdiction.
Well, Mr. Wilcox, there's no law. Congress didn't pass it. That's a rule from ATF.
Banning a class of weapons that you don't like the look of, not because of functionality.
Overall, the judge's interpretation hinges on the classification of short-barreled rifles as dangerous and unusual, as well as his distinct understanding of the Second Amendment in relation to accessories. His perspective differs notably from the Fifth Circuit's decision, emphasizing the complexity and ongoing debate surrounding this issue. Pistol brace ruling unpacked. The judge's denial of the motion for a preliminary junction hinges on his assessment of the plaintiff's case. He scrutinized their arguments and evidence, ultimately concluding that they did not present a compelling likelihood of success on the legal merits. This is a significant determination, as it means that, in the judge's view, the plaintiff's claims may not hold up in court. However, it's crucial to note that this decision is just one piece of a much larger puzzle surrounding the pistol brace issue. The controversy surrounding the use of stabilizing braces for arms is far from settled. Despite this setback, there are still several important factors at play. One key element to consider is the continued existence of injunctive protections. These protections were issued by the Fifth Circuit, along with lower courts within that circuit, specifically for members of organizations like FBC, GOA, SAF, and similar groups. As long as an individual is affiliated with one of these organizations, they remain shielded from potential legal repercussions related to the ATF's rule on braces.
If you were serious, you would acknowledge that 96% of mass public shootings happen in an area where guns are banned.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
This is a crucial safety net for those who support or belong to these advocacy groups. Looking ahead, there's another significant development on the horizon, the pending decision from Judge O'Connor in the Texas District Court. Judge O'Connor has garnered attention for his previous pro-Second Amendment rulings, particularly in cases like the Vanderstock ATF frames and receivers case. Given this track record, his forthcoming decision could be a game-changer. If he chooses to issue a nationwide injunction similar to the one in the frames and receivers case, it could have sweeping implications for the brace issue, potentially shaping the legal landscape in a profound way. In essence, the recent decision, while a setback for the plaintiffs, is just one chapter in an ongoing legal saga. The fate of braces, and by extension, the rights of arm owners, continues to hang in the balance. The interplay of legal arguments, court decisions, and potential future rulings underscore the complexity and fluidity of this issue within the broader context of the Second Amendment rights. Updates and implications. In the ongoing pistol brace lawsuit, the situation in North Dakota does not appear to be favorable for the plaintiffs. The judge overseeing the case in North Dakota has indicated a potential inclination to rule against them. This raises concerns about the outcome of the lawsuit in this particular jurisdiction. However, while the prospects in North Dakota may not be encouraging, there is some glimmer of hope for a more favorable outcome in the Fifth Circuit. The Fifth Circuit Court of Appeals has shown a tendency to align with the plaintiffs' arguments in previous cases related to the ATF's regulations on braces. This could potentially work in their favor as the case progresses through the legal process. It is important to note that legal proceedings can be complex, and outcomes can vary depending on the specific arguments presented, precedents followed, and the interpretation of applicable laws. Therefore, it remains to be seen how the Fifth Circuit will ultimately rule on the issue. Adding to the uncertainty, there are ongoing developments in the lawsuit that will impact its trajectory. For instance, the North Dakota District Court recently ruled against the plaintiffs, ruling in favor of the ATF. This ruling presents a setback for the plaintiffs, but it is not necessarily indicative of the outcome in other jurisdictions or at higher court levels. As the case proceeds, one key factor to watch is the ruling of Judge O'Connor in Texas. His decision will have significant implications for the broader legal landscape surrounding braces. All eyes are on Judge O'Connor, as his ruling could potentially shape the direction of future lawsuits and the ATF's regulatory stance on braces. It is essential to emphasize that the legal process takes time to unfold fully. Legal battles often involve multiple levels of review and appeals, requiring patience and adherence to established procedures.
Most significant federal gun restrictions in decades on Friday following years of false starts and failures to tighten gun laws.
Criminals will always find guns.
Absolutely.
And it is the cities with the most restrictive gun policies in the country where
the outcome of this particular lawsuit will depend on the arguments presented, the interpretations of the law, and the decisions of the relevant judges. While there is no certainty regarding the final result, it is clear that the issue of braces and the ATF's regulations surrounding them remain contentious and subject to ongoing legal challenges. These lawsuits play a crucial role in shaping the future of firearm regulations and have garnered significant attention from both arm rights advocates and arm control proponents. As the case continues, it is important to monitor developments and legal precedents in order to gain a clearer understanding of the potential outcomes and their broader implications for arm regulations in the U.S. Alternatives and proposed solutions. In addition to the ban on pistol braces, there have been discussions and debates regarding alternative measures and proposed solutions to address the concerns that led to the ban. These discussions stem from the recognition that arm safety is an important issue that should be addressed in a comprehensive manner. One of the alternative approaches that is being suggested is implementing stricter regulations and background checks for individuals purchasing arms and accessories. This would aim to prevent these from falling into the wrong hands, ultimately reducing the risk of misuse or harm. Another proposed solution is to enhance mental health screening and support systems, recognizing that addressing underlying mental health issues can help prevent incidents of arm misuse. By investing in mental health resources and ensuring access to proper care, it is hoped that potential risks and threats can be identified and managed more effectively. Additionally, there have been calls for increased funding and research into smart arm technologies. These technologies aim to enhance firearm safety by incorporating biometric or personalized features that restrict usage to authorized individuals only. While discussions and debates surrounding alternative approaches exist, it is important to note that finding a consensus on these measures can be challenging due to differing perspectives on arm control, personal freedom, and the interpretation of the Second Amendment. Ultimately, it is a matter that requires careful consideration and open dialogue among lawmakers, experts, and communities to determine the most effective strategies to address arms safety concerns while respecting individual rights. That's all for this video, folks. See you next time.